will be Sasser presiding.
Council ready? Good morning, everyone. Go ahead and be seated, everyone. Good morning, Council. Let's go ahead and first take up, is 8:30 ready? We're ready?
Yes.
What's that here? Come on. Good morning, nice to see you guys. And I did want to let you know that we are being videotaped and it's going to be posted on the on YouTube through Court Scribes, and it'll be on the court internet too, so you'll be able to see everything. So smile pretty for the camera. Okay? All right.
Thank you, Your Honor. If you remember, this case was tried. It was a slip and fall venue.
Biggs versus Uncle Mike's,
Yes.
Uncle Mick's, I'm sorry. Yes, I do remember the case well. And actually, we had one of your jurors come to our jury appreciation lunch too, who said he really enjoyed the trial. It was actually a wonderful, wonderful experience too. So,
I'm thinking of the gentleman, I think I know which one he was. I think the gentleman was in
the
it.
gentleman who asked the good questions as
Yes.
well, yes. He said he loved the trial. The only thing is that the only thing he was not happy about was the chairs were not comfortable. That was his only complaint, but he loved you guys and he loved the experience. So, but I read your motion for new trial. Is there anything you would like to add?
No, if you've read the motion, you know my position. That there are two issues that we present for reconsideration. The first would be the subsequent similar incidents, and we've cited the Glansburg case, and it says that subsequent incidents cannot be probative of prior knowledge. However, there are two ways under which a business establishment could be liable for slip and fall. One of those is regularity. So to prove regularity, we had evidence of prior and subsequent similar events. If we can't introduce the subsequent events to prove regularity, how else can we prove regularity of the condition if we can't offer evidence of that same condition occurring both before and after?
Okay, all right, thank you so much. Response, please?
Your Honor, on that point, the part of the statute that discusses happens with sufficient particularity or frequency, it goes specifically and explicitly to whether it was reasonably foreseeable. By definition, we're talking about prior knowledge.
Exactly.
And Your Honor, when you look at for instance, the Glansburg case, they said it's probative to prove that it was a dangerous condition if you have subsequent incidents. But that's not what we had at issue here.
Okay.
And also we had raised in our motion to exclude that if you're trying to prove it as these customers had a propensity to put it on the floor, based on what they were trying to prove, that's character evidence. I mean, that's a prohibited way of trying to prove it.
Okay, all right, thank you so much. Anything else on your motion?
For the first part,
Yeah.
not so much, no.
On the second part, let's
On
finish.
the second part, yeah, we had a large discussion on golden yachts and spoliation. You provided us with your order and
I
the
do,
Silkworth
yeah.
case, and reading it, I haven't changed my position. The first prong, it existed at one time. We agree on that. It did. Second prong, duty to preserve. We realized that death snare standard controls. It's reasonably foreseeable that litigation could arise. In the testimony of the owner of the defendant, he said that he received the incident report, and the reason that those are generated is a visible incident that could offer up some form of liability. That's not tantamount to an admission that litigation was indeed reasonably foreseeable. I don't know what it is.
Okay, well, I think it's the third prong that's the most challenging prong under golden yachts, not the second prong.
Maybe.
And that's the issue that we had. Response to the golden yachts argument?
So, Your Honor, cited extensively was the Silkworth case, which Your Honor was kind enough to provide us the order on. Two things to distinguish that one. The first was that, and I understand what counsel was saying about the incident report, but I want to point out that I don't believe that's exactly what the testimony was.
Okay.
They said that any time that somebody falls or there's any type of incident that occurs, as a matter of course, they generate an incident report. And in actuality, we didn't claim work product privilege over that incident report. That's why they had it.
Correct.
We didn't think that there was a reasonable anticipation of litigation. And the record was that there was no notice of claim, request for insurance disclosure, anything like that in a time period, which was 3 weeks, that it would have been written over. So I think that there's still an open question about whether or not there would have been a duty to preserve it. In the Silkworth case, it's completely the opposite. They actually called it, and I think they called it an adverse incident report or an adverse treatment. And they literally had gone to the paramedic and said, this might be something that needs to be followed up on, because there were concerns about something having been missed. So they already were, literally during the treatment, thinking that there might be litigation that comes from that, and preparing for it. So I think that was how the court was able to determine that under the Densner and League of Women Voters standards, that yes, you could determine that there was a duty that existed under this one.
Okay.
Then going to the third prong, which Your Honor was referring to, during the case, we had established that we still had the same footage, in other words, the same cameras. Nothing had been changed. That had been asked about, nothing had been changed. And what we don't know, particularly in light of this particular circumstance where you have a small amount of powder on a part of the floor that's right next to a wall, is whether or not any of that would have been depicted in the video and whether or not you would have been able to see it. And the issue there is the only thing that they're trying to say that video would have been probative to is how long it had been on the floor. And bear in mind, this is a dance floor that's being used.
Sure.
And so the problem is that unlike in the Silkworth case where Your Honor made the determination that if the patient had been moving her limbs, it would have been obvious
Sure.
from the video. It wasn't a question
Okay.
with respect to the CCTV footage that was there. What the defendants in those cases were trying to say, or in that case was trying to say, was that it's speculative as to whether or not she would have been moving her limbs, which you said was precisely the problem.
Okay.
Here, it's speculative as to whether or not the video could have possibly picked up
Captured
anything that they're trying to get at.
Okay, all right, thank you. Last word?
Moving on to the second part, the adverse incident report, and Silver, that goes to reasonable foreseeability. I don't think that's an issue. The defendant, the owner of the defendant, the corporation did say, when I said offer up any form of liability, that's from page 292 in the trial transcript. But like you said, that's not the issue. The third prong is probably the issue.
Okay.
So similar in Silkworth, if you saw the plaintiff moving, then it would be obvious. It's obvious that you can see the plaintiff moving, that would prove something. If you see the defendant or an agent of the defendant spill a drink on the dance floor and neglect to clean it up, or many things could happen, why would that not be probative in this case, relevant in this case as well? The video of the incident itself, exactly, there's speculation that it could have shown the powder, that it could have shown negligence. That's the point, there's speculation. We don't know what it would have shown. It very well could have shown anything.
Okay, all right, thank you so much. Excellent job in your motion. I'm going to deny the motion, plaintiff's motion for new trial. Thank you guys so much. Have a great day, everyone. Let me please go ahead and start with UMC this morning. Folkowitz Homeowners Association versus Schallenberger. Councilor, ready on that one? Good morning.
Morning, Your Honor.
Good morning. And that read your motion. You may proceed. This is the amended motion to continue the trial. So yes, anything to add to your motion?
No,
Okay. No, I'm happy to do that then. Do you want a new date, or what are you requesting for the trial?
I'm being told that this short sale needs to close by the end of February.
February.
The whole thing falls apart.
Okay.
We're already positioned to have our summary judgment heard.
Okay.
So, so it's in my interest to move it forward. So I think I just need stricken from.
You just need it stricken? Do you need another date or anything for the trial, or you just need it stricken?
It's up to you.
Okay, that's fine. Michelle, let's give them a new date for trial. We'll go ahead and set it in early March then. If the short sale goes through, that's wonderful. If not, then we'll have a trial date for you.
I appreciate it.
Okay, all right, thank you so much. All right, let me go ahead and do City of Pahokee versus Techno Marine Construction. Councilor Reddy, good morning.
Good morning.
Good morning. This is the motion to strike defendant's pleadings and for entry of the final default. And I read your motion, Mr. Rainberg. Anything to add to your motion at this time?
No, Your Honor.
Okay, I'm going to go ahead and grant it then.
And present the
Sure,
order.
you can just hand this to bailiff then. Thank you so much. Have a great day.
Thank you.
Okay. Foreclosure case, Wells Fargo Bank versus unknown trustee of Stu, Christina Stu.
Good morning, Your
Good
Honor.
morning. This is the foreclosure non-jury trial. You ready?
It is, Your Honor. I am Hillary Mullen for the plaintiff. I do have an original business records affidavit for you, as well as the proposed final judgment. Notice of intent was filed in November.
Yeah, no, you did everything correctly, and there's no opposition. When would you like your sale date?
45 days. Your
45
Honor.
days. All right, Michelle, give you 45 days sale date then.
Thank you, Your Honor.
All
May I?
right. Yes, just hand the package up to Michelle. Thank you so much. Have a great day, council.
Thank you, Your Honor. Have a good day as well.
Thank you. Let me go ahead and do Selman versus DIMI Nursing, please. Defendant's amended motion to continue. Good morning, guys. All right, good morning. We shouldn't have an issue with that. I'm happy to set your trial whenever. So we'll do it after the conflict is over, if that's okay with council.
Right, we were just wanting clarification if you were willing to special set the trial date.
I special set everything. Yeah,
All right,
absolutely.
well,
Let me know the dates that work. Do you guys want to check with your experts? Email me the dates that work, and I'll be happy to give you the date right now, so you guys can let your experts know, so it's nice and
We
easy.
don't have any.
Oh, well, you don't have any. Oh, maybe defense has experts.
We do.
Okay, Your Honor. Just let me know when your expert's available. All right, thank you guys. Have a great day. All right, let me go ahead and do Gun Club Cafe versus Bay Hill Group, please. Plaintiff's motion to compel defendants to return computer system. Council ready? All right, good morning, everyone. Do we have a court reporter on this case? No? Okay, all right.
Actually,
Yes. Okay.
would you take
Good morning, everyone. This is Gun Club Cafe versus Bay Hill. Good counsel, please state their appearances for the record.
Yes, Your Honor. Jeffrey Putnam on behalf of the plaintiffs.
William Pincus on behalf of the defendant counter plaintiffs.
All right, good morning, everyone. I read this is plaintiff's motion to compel defendants to return the computer system, and I read your motion. You may proceed when you're ready.
Thank you, Your Honor. Excuse me. You've read my motion, Your Honor, but just as way a little background, since it's been a long ongoing case.
It has, yeah. This has been going on for some time.
We had a bankruptcy that was in the middle of it, so
Yeah.
it's been a long road. And I'm the second or third counsel, I can't remember. Anyway, Your Honor, this is the original complaint. The complaint is my client sold a restaurant to the defendants pursuant to a note, a contract. No payments were made after the defendant started running that, and my client took back possession of the restaurant, presumably all of its assets. A POS system that had gone to the defendants along with the sale of the restaurant was kept by the defendants after my client took possession of the restaurant back. It has, presumably, information regarding when my client was running the restaurant and when the defendants were running the restaurant, which is important for both sides.
Sure.
Defendants have had possession of that point of sale system
For some
since
time.
2010.
Okay.
They've run analysis on it because we have affidavits from previous motions. In fact, there was an affidavit submitted as part of a motion for leave to add punitive damages. So, from an IT expert who has already, they've done an analysis. They know what's on the POS system. I'm simply asking for it, in whether it be just held in my office so
Okay.
that no one has any problems with possibly the plaintiffs spoiling any evidence. We like to run our own analysis on the POS system to find out the information on sales and things that were done when it was in possession of the defendants.
Okay.
And that's all we're seeking.
Thank you so much, Mr. Pepper. Response, please, Mr. Rickles?
Your Honor, did you receive my response?
I did.
Thank you. Then you'll know that our position is that there's nothing in front of the court to exercise its jurisdiction over, and if there were, this would have to be an evidentiary hearing. He hasn't requested an expert to come inspect.
Okay.
There's no count for replevin. You've read my motion.
I have
know
indeed.
these things, so I'm not going to sit here and waste your time, but
Okay.
there just isn't anything here for the court to exercise.
Well,
its
rather than,
jurisdiction or
and I
leave
agree
that
with you, I
evidentiary
can't
hearing.
seize it, obviously. This is an injunction relief where I could potentially seize it, but he would have the right to, well, what about discovery? Would he have the right to discover what's on the POS system, right?
Unquestionably, but he hasn't asked.
Okay. Okay, all right. So if I have him do a formal request to inspect under the rules of evidence, would that be acceptable? So he could do that at that point? And then could I have you do a duty to preserve where there would be no change to the POS system as well?
Yeah, absolutely, Your Honor. I just want to make one point clear. He hasn't requested an
Okay.
expert inspection
Okay.
at no time. He's
Okay.
requesting that we turn over the device.
Okay, okay, all right, so maybe that's the first step then. Can we go ahead and have you send by 5 o'clock today, a written request to have an expert inspect it? And what I can certainly do is I could go ahead and we'll have an independent expert be able to inspect it. That's your right under the rules of civil procedure. And that way that expert should be, if it's a good forensic expert, should be able to say if any changes were made to the POS system as well then, and you guys can coordinate that. And then if necessary, we can have an evidentiary hearing to seize it, to maintain it in an independent third-party control, so that way no changes, if your expert determines there's something bad happening with the
Well,
POS
we
system.
just want to pull the information off.
Okay, oh, that's easy then. Okay, so then at least we'll do it step by step. So I agreed, so let's go ahead and have you send a written request. If there's any objection, you can file any objection, I'll be happy to hear it. But at this point in time, I'll deny the motion to go ahead and order return a computer system, but I will certainly allow the expert to inspect the computer system.
Thank you, Your Honor.
All right, thank you guys, great work. Have a great day, everyone. All right, let me go ahead and do Kelman versus Calusa Transport, please, motion for leave to add party. On both sides here?
Your
No?
Honor, I think we're waiting on defense.
Okay, no problem. Bayview Loan Servicing versus Celestine, motion to continue. Council ready? All right, good morning.
Morning.
Good morning, this is Bayview versus Celestine. Defendant's motion to continue, the summary judgment hearing. And I read your motion, is there anything you'd like to add?
No.
Okay.
Good morning, Your Honor. You have the floor, the motion for summary judgment.
Judgment, yeah.
Okay. The only thing to add is I do have the original now.
Okay, all right, so, yeah, so, do you have, let's talk about the motion to continue versus anything else? She's got the opposite, she's got all the materials on
Well,
summary judgment.
the motion to continue, the only thing that we ask is to continue it for maybe about 20 days so we can just renotice, coordinate, and do the deposition of the complaint verifier so we can have our evidence, so we can put together an opposition affidavit.
The only thing is, under Rule 1.15, you have to indicate which specific depositions you take. need to take? Was that done under the rule for the continuance of the summary judgment hearing?
I don't believe it. I mean, we obviously object, Your Honor. I mean, they waited until January 9th.
Yeah, you waited until
Notice.
January 9th to
And we
request.
set this hearing back in October, and it was a day that everyone
Yeah.
agreed to.
Your Honor, the witness didn't show up to the deposition.
Okay, but then why not move
Maybe
to
it's no
compel?
longer the plaintiff anyways, and they know this because there was an order substituting.
Oh,
Marty
so it's not even the right
March.
witness.
Right, so,
That's the problem, it's not even the right witness. So I'm going to deny the motion to continue. Anything in opposition to the summary judgment at this time?
I don't have anything
Okay,
to oppose.
that's fine. Then, which sale date would you like?
next available, Your
Okay,
Honor.
Michelle, 35-day sale, okay? All right, thank you guys so much.
All right, thank you.
Thank you, everyone. All right, let me go ahead and do Webster versus Citizens, please. Motion for leave to file the amended complaint. Good morning. Good morning. This is Webster versus Citizens. Motion for leave to file. And I read your motion. Is there anything you would like to add to your motion?
Just very briefly, which is requesting that everything we heard at during defendant's special set motion for summary judgments and consolidations were incorporated.
I think that's fine then. I'm going to go ahead and grant it just to an amended order setting, so that way you can list all the issues at the same time.
I think the opposing counsel's bureau with the phone.
Oh, okay, I need a phone number then. Do you have a phone number?
305.
Oh, this is the 305 number. Oh, okay, 305, yes. Okay. 905, is it 905-6365?
That's it.
Okay, right. Oh, thanks.
Hello?
Oh, counsel, good morning. Is this Mr. Tim Ramon, please?
This is he.
Good morning. This is Judge Sasser. I'm calling you on Webster's versus Citizens, and counsel's here on plaintiff's motion for leave to file the amended complaint and wants to have all the matters heard at the same time. Is there any opposition?
Opposition to...
The motion for leave to amend, first of all.
Oh, yeah, that's what you're voting.
Okay, all right. Okay, so you want to, but you want to set, is it okay to set everything at the same time?
Set everything in, I'm sorry.
One hearing. You have a hearing currently set, is that correct?
Correct, the motion for a leave to amend.
Yeah, then we'll just do everything together then. We'll do your response and opposition on your paper, your motion at the same time?
Yes.
Okay, that's fine. We'll do all the motions at the same time, if that's
I
okay.
see what you mean, I got it,
Okay.
thank you.
Yeah, that's fine. So just go ahead and send me an amended order setting hearing.
All right.
All right, thank you guys. Have a great day, everyone.
Thank you.
Thank you.
Bye.
All right, Wells Fargo Bank versus Desmond, please. Motion for default. Council White? Good morning. Hello. Good morning. This is Wells Fargo versus Desmond. This is the motion for default. And I read your motion. Would you like to add anything to your motion?
Yes, Your Honor. Ms. Desmond actually filed an answer, or filed a paper.
Okay.
So I've...
Yeah, we can't get a default then. I'm glad you called.
I'm Miss Desmond,
Okay,
Your Honor,
great.
so.
No, that's great. That's
Just coming up
exactly.
here to see what's going on.
Yeah, all you needed to do was file anything, so I'm not going to grant the default, and you filed a paper. Do you want to consider, deem that your answer? Is that your answer to the complaint?
I'm not sure.
Oh, I can't give you legal advice.
Yeah, that's okay.
Okay, so that's okay? You want to keep that as your answer?
Yes.
Okay, all right.
I just wanted to find out that, you know, that they were going to, prepare an order denying the motion.
Motion's denied.
Okay, good.
Yeah, no,
I
motion's
didn't hear it
denied.
in the order that's denied that her filing was...
Yep, you got it
deemed an
exactly
answer.
right. Motion's denied, and you filed your answer. All right, thank you. Do you have any questions?
No.
Okay, all right, thank you. Have a good day. See
Thank
you
you, Your
around.
Honor.
All right, Wilmington Savings Fund versus Celestin. We did that one, that motion for summary judgment. Okay. U.S. Bank versus Koliski.
Yes, Judge. That is mine as well.
Okay.
Good morning, Your Honor.
Good morning.
Kristen Ritchie on behalf of the defendant.
Yeah, that's defendant's motion, extend sale date and compel requested information. When would you like the sale date to be reset?
If we could get a deadline of
Okay.
10 days for the information, then I think 30 days would be.
Is that acceptable? Okay, 10 days is fine. So let's put that in the order. 10 days for the information, and then let's do 30 days then for the sale, if that works.
Okay, very good.
Perfect.
Thank you.
Excellent. Another foreclosure, Wells Fargo versus Binns.
Yes, Judge, it's mine as
All
well.
right, that's motion to reset, right?
That's a motion to reset. It's a little different than your normal situation.
All
I'm
right,
not sure if you
are
had a
you
chance.
Mr. Binns?
No, I'm the property owner.
Oh.
My attorney is on his way.
Okay, that's
I
fine.
wasn't notified of the
Oh,
amended hearing.
okay.
2:30.
Property, you bought the property at sale?
No, I own the property
Okay.
from Vince.
From,
February investments.
oh, it was sold before the sale.
Yes.
Exactly.
Okay.
And if you'd like, I can.
Yeah, that's what, your attorney's on the way?
Yes.
Okay, we'll call him in
Okay.
just a minute. Okay.
Sure.
It's a bit unusual. Okay. All right, CIT Bank versus Vasquez, please.
That's
Motion
my-
is yours? Okay.
that's
So
my
motion to
last
sub. Yeah, that's fine. I'll go ahead and grant the motion to sub.
Great.
Just
Yeah,
hand
approach.
that- Yeah, just hand that order. All right, so.
Thank you.
Yes.
But Holston Council's trying to call you back.
He doesn't call back. The hearing's over. So, that's fine. City of Pahokee versus Techno Marine Construction? Anyone here on City of Pahokee versus Techno Marine? No? Okay. All right, Star Insurance versus Kelman? That's all right. All right, good morning. If anybody else has any paperwork, just make sure the bailiff has it. I only have paperwork on 2 more cases, so I'm missing paperwork. All right, Star Insurance versus Kelman. Good morning. Good morning, everyone. We have court order? No? All right, this is counter defendant's motion to show cause, and I read your motion. You may proceed when you're ready.
All right, Your Honor, we actually just resolved one of them. The records custodian for Palms West just came in.
Excellent, good.
So we don't need to worry about that for now.
Okay.
The other is the office of Dr. Rorman. They did not respond to subpoena. I have the notices here showing that they were noticed of the subpoena and of this motion today.
That's fine, and nobody's here for them, right? Okay, any objection to the show cause, then you're entitled to it. So we'll set that out 30 days, and then we'll do the show cause hearing.
Okay.
And just make sure you get service on them, so they have notice then.
I will, Your Honor.
Okay. All right, any other parties, or is that the only?
One more thing,
Yeah.
counter plaintiff has read Council's motion for leave to amend.
Oh, yeah, I read that. Is there any opposition to the motion for leave to amend? Okay, we're gonna go ahead and grant that and deem that filed as of today's date.
And then we've agreed that all discovery to LLC will also relate to LLP.
Okay, you wanna put that in the order? That would be great then.
Yes, Your Honor. And
Okay.
we also agreed, and I'd like to ask Your Honor, is this going to take it off the trial document?
Yeah, you're no longer an issue with the motion to amend, absolutely. You're off the docket then as well. Michelle, they're off the docket. All right, thank you so much. Have a great day, everyone. Okay. This is telephonic, Bruno versus Benedetta. All right,
And I'm on this one, Your Honor.
Okay. We're getting counsel on the telephone.
Your call has been forwarded to
That's
an
not a good
automatic
sign. Do we have another phone number?
I have their office number, that was the number.
624.
Yeah, let me try another number.
The office number for our assistant is 561
561
826
826
5200.
5200, okay.
And Ms. Klein's assistant's extension is 288.
Okay, let me give him a call.
I'm sorry? I know I'm here. It's Arizona. I keep it here.
Thank you for calling the Vernon Law Group. If you know your... Please wait while I try that extension.
Numerous other offices across the state of Florida. We will be there when your family needs a personal injury attorney. Thank you for holding.
You've reached the customer Shelby Krieger. I'm going to
Strike two.
your call right now, so please leave your name, phone
Do you want to
number.
go outside and see if we can try to reach him, and then we'll try again?
The reason why you called.
All right, let's go ahead and do, no problem. Let's do Feigenberg versus Palm Beach County. That's right. Okay.
Morning, Judge.
Good morning. This is Feigenberg versus Palm Beach County. We have a court reporter. If all counsel could please state your appearances for the record.
Mayor Bannick for the plaintiff. Kathy Lindsay on behalf of Palm Beach County.
Mitch Catlin on behalf of Gerald DeSisto.
All right, good morning. This is plaintiff's motion in limine, and I read your motion. You may proceed.
Your Honor, if you've read my motion, let me ask you if you have any questions. Usually you're prepared to.
No questions, response?
I have no problem with her order.
Okay, that sounds fine. We're gonna go ahead and.
Your Honor, I-
Oh, yeah, oh, you may have a problem,
I
yeah.
do have some problems.
Sure.
I'm not sure what they're referring to, but we have some, certainly don't agree to, we only agreed to 2 and 6, paragraphs 2 and
Okay.
6. As to number 1, prohibiting the defendant from introducing evidence that plaintiff has had plastic surgery related to injuries, we think it may be relevant.
What issue does it go
Related
to?
to her injuries.
Yeah,
Unrelated to her injury, I apologize.
unrelated, yeah, so what does it go to?
Reason why it's because of elective surgery, she's had recommendations to get a surgery for the accident, for the injury involved in the accident. She's elected not to have that surgery, but she has elected to have plastic surgery. We think it's very relevant to that issue.
Your Honor, there is no recommendation that she have a surgery. She's had 3 surgeries.
Okay.
So she's had 2 on her knee, 1 was to remove hardware. There's no, there's a recommended for a knee replacement in the future.
Okay.
But nothing that's
Current.
immediate.
Okay, that's different then. So I'm gonna grant that part of the motion limiting without prejudice.
Okay, Your
All
Honor.
right.
Number 3 is prohibiting the defendants from inquiring into plaintiff's prior work history because she's not making a wage claim. The only problem we have that, Your Honor, is it might be relevant depending upon what she testifies to at trial.
If she opens the
especially-
door, we can always come in, so I can grant that motion limiting, but if somehow the door is open, it's always without prejudice.
All right, Your Honor. And the last one, Your Honor, is number 5. It states prohibiting the defendants from introducing any evidence that plaintiff's late husband committed suicide.
Yeah, what issue would that go to?
Just to back up, Your Honor, her husband committed suicide in November 2014. Our date of accident is 15 months later, March 2016. The complaint alleges that she suffered mental pain and suffering from our accident. The complaint also alleges that she suffered psychological and emotional damages from our accident. Certainly, the fact that her husband committed suicide within 15 months before our accident is certainly something that is relevant, especially when it goes to mental pain and suffering, also to her psychological and emotional damages.
Have you had her examined by a CME physician who can tie this up and say that her pain and suffering might relate to the suicide as opposed to the accident?
We have not.
Okay, all right, response?
Your Honor, I think they just want to paint her, in a bad light here, and there's no relevance here. She has testified that she was on Lexapro before the accident. She's on Lexapro after the accident. There's been no change in dosage. And I think it's highly irrelevant and inflammatory here to let this in. And, she doesn't need to go through that on the stand. She's been through enough.
What issue does it go to in the lawsuit then? I mean, she's going to concede she was on medication for depression beforehand.
Again, it goes to the long-term effects of the suicide of her husband and how it affected her and how it's gone into, and how it goes into the allegations that are contained in this complaint,
Okay.
dealing with the psychological damages she's claiming from our accident.
Okay, I'm going to grant that part of the motion limiting without prejudice, unless you can get me an expert or someone to opine on the stand that her damages and her pain and suffering could be related more to the suicide as opposed to the accident. If that is, then that potentially would be germane. But at this point in time, on a 403 analysis, I'm going to exclude it because I think the prejudicial value is outweighed by the probative nature of it.
Your Honor, the one he didn't mention was prohibiting the defendant's compulsory medical evaluation physicians from testifying outside of the opinions contained in their reports. He did not agree to that. If he's agreeing to that now, I'm fine.
Yeah, no one's going to
It should be
testify.
as to all experts.
Yeah, that rule applies to all. Like, they're limited to what's in their opinions and their
I believe
reports.
we did have an agreement on that.
Okay, all right, that's fine then. Okay, sounds great then.
You're
All right,
you're
thank
in
you
order,
guys.
but then I have
the
the county. has
Yeah,
a
let's do the
motion.
county's motion, yeah.
My motion of limine is bifold. One is on the issue of vicarious liability. This accident arises out of her client was hit as she was walking across a golf cart path by
Yeah.
his client who was driving the golf cart. Our client, the county, owns a golf cart. Under the Rabideau case, there is no cause of action for vicarious liability. Florida Supreme Court case, and my understanding is she's not opposing this motion.
Yeah.
I want to preclude reference to any issue of vicarious liability on the county's
Okay.
behalf because it's prejudicial.
I think so. There's no
No,
opposition?
Your Honor, I'm on top of the case law. I
Okay.
couldn't mount a defense.
Okay, you're exactly right, so I'm going to grant that motion.
The second one, and I asked his office yesterday if they would agree to it, and apparently they were opposing it. The next issue is on signage. As Ms. Friesenberg was crossing the golf cart, the path, Mr. DeSisto was coming along the golf cart path, and this pedestrian path as well.
Okay.
Mr. DeSisto made some comments in his deposition that there was no striping or crossing or signs.
Okay.
That was not pled.
Okay.
It was not litigated. And even if it were, the county would have sovereign immunity
To
for
the-
any
absolutely.
signs. So my motion is to preclude any reference to the absence of signs, crosswalks, warning signs, anything
Okay.
of that nature where she crossed the path.
Thank you, Ms. Lindsay. Any response?
Not for me.
Okay, yeah, that's not an issue. They're not gonna bring it up.
Well, Your Honor, it is because the apportionment of negligence to the Palm Beach County is certainly an issue, and under Fabry, we certainly, the apportionment of damages as the percentage of fault.
But
that Palm Beach County
but
has.
plaintiff's not even alleging that Palm Beach County did anything wrong with that signage. So
They're
how can the
alleging
defendant
that-
point the finger on it when there's no claim in this case for that?
They're alleging that the bushes obscured, that the bushes were too high.
That's different than signage. So
We're not
motion's,
talking about the bushes.
okay, motion's granted.
Well,
All right,
order.
all right, thank you guys, have a great day. All right, let me go ahead and do City of Pahokee versus Techno Marine. Do we have a team yet? City of Pahokee, Techno Marine? No? Okay, Old Bruno Jones, we're still waiting to see if we got a team outside on that one. Wells Fargo Bank Bins? Wells Fargo Bank Bins? All right. You still waiting? Oh, still waiting? Your attorney's still coming up? Okay. And then Kelman versus Calusa Transport. Yeah, let's do the CMC. Come on up on the CMC. Okay, that's fine.
Any CMC?
All right, yeah, CMC, yeah, no, that's your CMC. Well, this is Ted versus Garrett. Is that yours?
fine.
Oh, good morning. All right.
Robert Bergman on behalf of Mr. Dugas.
Yeah, what is the status of this one? Oh, here she comes, okay. All right, good morning. It's a 2011 case. And what's the status at this time?
This was a case that was set for non-jury. The, I think almost literally on the eve of trial, counsel passed telephone chambers issued this roughly 60-day CMC.
I did.
There was a gentleman who was helping the deceased, at least in this case, I think maybe in some others I've spoken with in the last couple of days.
Okay.
Last night when I last spoke with him, he said that defendant may be here, otherwise, from our point of view, it's a half a day issue.
Ready for trial?
3/4 of a day, non-jury trial, ready to go.
I want to set it. And can I set it for trial?
Yes, I'm Ann Principe, and I don't have counsel as of yet, so
Okay.
I'm as of just 2 days ago.
Okay, I have to set it for trial. It's a 2011 case.
Right, I know,
Yeah.
it's crazy that it's done.
Yeah, so, okay, so we'll set it for trial within 30 days then. Half day non-jury.
Should I, what's that?
Yeah, just put that Norm, and Michelle will send you trial order then as well.
Thank you.
All right, thank you so much. Thank you, have a great day, everyone. All right, we're just waiting on the last few teams.
We have one more.
Oh, come on up. And which, oh, yeah, you got the other side?
Yes.
Oh, great,
I
okay.
just spoke to her on that number.
Okay.
She's waiting.
Oh, she is, okay, great. Let me call her.
Hello?
Oh, good morning. This is Judge Sasser. Are you ready on Bruno versus Di Benedetto?
Good morning, Judge.
Good morning. This is defendant's motion to tax costs, and we have a court reporter. If counsel would like to state their appearances for the record.
Good morning, Your Honor. Erica Miller for the defendant.
Courtney Klein, I represent the Berman.
All right, good morning. And we have set for hearing this morning defendant's motion, tax cost, and I read your motion. You may proceed when you're ready.
Your Honor, this is our motion to tax costs pursuant to Florida Rule of Civil Procedure 1.420. We filed the affidavit of cost. In this case, plaintiff files a voluntary dismissal on November 21st, 2018. In our answer and affirmative defenses, which were filed with the court on September 25th, 2018, we did request our cost and any approval for the demands.
I think you're entitled to that. Let me hear, is there any opposition to the cost?
There's not, it's just, we're just appearing to make sure that it's the client, that Ms. Jones and Mr. Bruno and not us.
No, it won't be the law firm. It's the client.
Yeah.
So I'm going to grant, absolutely. I'm going to grant the motion tax cost under the rule, and we'll do a final judgment for costs then. All right, thank you so much. Have a great day.
Thank you.
Thank you very much.
All right, so let me know when we have any teams ready. You can just, so I'm still waiting on Kelman and Wells Fargo Bank and City of Pahokee. Those are the three we're still waiting on. So, and if anybody's, both sides are here for the 9:30, we can get set up. Okay, Sharon?
On 9:30?
Okay, go ahead and you can get set up.
Okay.
So yeah, we're waiting on the attorneys on the 9:30 then.
Okay, how was the...
Okay, all right, let me know when we have any teams ready on the 9:30.